Today, we're going to walk through a really tough but incredibly important topic for families here in Washington, D.C. We're talking about what happens when substance abuse allegations come up in a child's custody case. The D.C. Superior Court has a very specific way of handling this, and understanding that process is absolutely key. So, let's get right to the heart of it. The big question is this: how exactly does a judge in the D.C. Superior Court look at these claims? If you're a parent on either side of this issue, knowing the answer and what the court is looking for is gonna be a game changer. Now, before we even get into things like evidence or testimony, we have to start with this single most important concept, the one principle that guides every single custody decision made right here in the District of Columbia. Everything else, and I mean everything, flows from this. And there it is. This phrase, the best interests of the child, isn't just a suggestion, it is the legal standard. Every piece of evidence, every argument made, every decision a judge makes is all seen through this one single lens. It's the absolute North Star for the entire process. Okay, so how does substance abuse fit into that best interest standard? Well, the court's concern isn't really about making a moral judgment on a parent. Instead, it's all about one thing: evaluating risk and a parent's actual ability to care for their child. So here's the key. The court really defines the problem by its effect on the child. The question a judge is always asking is, does this parent's substance use get in the way of them providing a safe, stable, and nurturing home? Proving that connection is what matters. And if that connection is proven, well, the consequences can be incredibly serious. The court has a number of options to protect the child. It could mean anything from restricting visitation to requiring that all visits be supervised. It could even lead to Child Protective Services getting involved, or a parent losing physical or legal custody. Make no mistake, the stakes are very, very high. So with stakes that high, how does a judge decide? This really gets to the practical heart of it all. Whether you're the parent who is worried or you're the one being accused, what kind of proof actually matters in a DC courtroom? Because it's not about what you think happened, it's all about what you can actually prove. And this is just so important to understand. A judge in D.C. Superior Court is not going to make a life-altering decision based on accusations alone. They need hard, objective evidence that shows not just that a parent is using a substance, but that it's having a direct, negative impact on the child. So if you're the parent raising these concerns, documentation is your single most powerful tool. This is your playbook right here. You have to be meticulous. Write down the exact date and time. Describe precisely what happened, and list anyone else who saw it. This turns a vague complaint into a credible, factual record. And here are some great examples of the kind of evidence that carries serious weight. Things like court-ordered drug tests, police reports, or DUI convictions. Those are powerful because they're official third-party documents. They aren't just one person's word against another's. Eyewitness statements can also be really crucial here. But a finding of substance abuse isn't always the final word, and that brings us to a really critical turning point: recovery. The court is very, very interested in what a parent is actively doing to fix the problem. Just look at the difference here. It's two completely different paths. On the one hand, without any recovery efforts, a parent is seen as an ongoing risk to the child. But with proven, demonstrated recovery, the whole story changes. The court now sees a parent who is committed to their child's safety, and that can open up a path to more visitation or even getting custody back. So how do you show that commitment? Well, just like before, it's all about the proof. Things like a certificate from a rehab program, sign-in sheets from support groups, letters from therapists, and, of course, a solid track record of clean drug tests. These are the tangible things that show a judge you are serious. All right, we've talked about how the court thinks and what it looks for. Now let's talk about what you should do. If you find yourself in this situation on either side, what are the first, most critical steps you need to take to protect your child and your own rights? Here are your immediate priorities. First, document everything, whether that's incidents you're concerned about or your own steps toward recovery. Second, build a support system. This is way too much to go through alone. And finally, and this is crucial, talk to a DC family law attorney who has experience with these exact kinds of cases. You need someone who knows the system here. We've really covered the essential framework today, but of course, every single case is different. For a much more detailed breakdown of the laws, the court procedures, and the resources available here in DC, you should check out the comprehensive guide from the Lopez Law Firm. It's the source for this explainer, and it's a fantastic next step.